Okay, this is sort of the season for, well, it's IEP season, but it's also where we see sort of an increase in behavioral issues. Not that we don't see them a lot in the first semester of a school year, but we tend to, the closer we get to the end of a school year, we tend to see an escalation in behavioral issues with students with disabilities. Um, and I could give you a whole litany of reasons why, but I'm not going to. Let's just cut to the chase. I think it's important for parents to understand sort of the procedure behind what's called a manifestation determination hearing, okay? And it's not a hearing in the same way as, let's say, a disciplinary hearing. They're not the same thing. A manifestation determination is more of a safeguard that is used or intended by the IDEA and 504 in order to ensure that the students' procedural safeguards and their accessibility to a free, appropriate public education remains intact, okay? And so it sort of creates an extra step for the school system if they're proposing a change in placement, meaning let's say that they, the child, they say violated a student code of conduct, and at that point the school says, well, we want to send the child to alternative school for 45 days. Well, that means that they're not in their designed IEP least restrictive environment. And if the proposed placement is for more than 10 days, they need to have a manifestation determination meeting or hearing in order to take that extra step to analyze, and this is key, whether the child's disability had a substantial relationship to whatever the infraction was, okay? And let me go ahead and sort of run a tangent here on where some schools really screw up. You have a child's eligibility category, okay? And it could be, one of 13, if most of the states recognize 13. The federal government recognizes 13 possible eligibility categories that the child can qualify under with regards to being eligible for an IEP. Okay, now a 504 is based upon the child's disability, just whatever their diagnosis is. But yet, children with 504s have the same procedural safeguards with regards to a manifestation determination, even though it's not referenced in 504 at all. There's just been OCR decisions and other things, court decisions that have backed up that they are entitled to the same procedural safeguards as children who have an IEP. So it's based upon the diagnosis. Now I have many schools that screw up with that interpretation, and I can name one specifically. Let's just call it Birmingham City schools. And I've had many over the years where there's an overrepresentation of specific learning disabilities, okay? But that doesn't necessarily mean that that's the child's disability or their diagnosis. And what they do is they apply the manifestation determination question or standard as to whether their category of disability has a significant impact or relationship to whatever the violation of the student code of conduct that they believe occurred. Okay, guys, that's not necessarily lining up, because I've had many kids that they don't qualify under autism, for example, or they don't qualify under ADHD, or they don't qualify under emotional disability, and but they do qualify as a specific learning disability. Okay, so what? The category of what they qualify for an IEP has close to zero. Sometimes they line up, sometimes they don't. You have to base it upon what the child's diagnosis and disability is, okay? Just like you would for 504, you would need to apply that standard. What is the child's disability? And there could be multiple disabilities. So schools will play that game. Some schools will play that game. I mean, some schools, it may be just a factor of ignorance, okay? But, whether you're ignorant or not is not an excuse for violating or trampling on a child's rights, okay? And then not only that, is as a school system, it just gets you into potential problems. If the parents end up finding somebody like me and I end up doing a little bit of scrutiny and digging and find out that was a really lazy decision by the team to look at something as arbitrary or subjective as how the child qualified for an IEP, as opposed to what is their known and unknown disabilities. What is their diagnosis? What are the issues? Okay. So with that being said, taking it back, that's the first analysis. Did it have a substantial, did the nature of the disability have a substantial relationship to whatever the violation that they're being accused of is? And you sit there and you go, there's a lot of schools that sit there and say, well, James, this is just an excuse to have kids avoid consequences and have kids avoid punishment. And that's such an archaic way of looking at life, guys. There are a myriad of explanations for things. And I am not one of those to where I think that's the nature of government. I think government expects there to be an ounce of a pound of flesh that somebody must pay for some kind of perceived, violation. And I wish in that respect we were a little bit more like Europe, that we don't look at it like that. But, we're very American, and Americans love to incarcerate people, and we, expect there to be consequences for everything that occurs. And I think that there needs to be a balance there. I don't think it's that simple, but that's how schools operate. Schools operate off this idea that there has to be a punishment and there has to be a consequence. But I think that that's where the thought process behind a manifestation determination is actually very good, because what it does is it does provide that extra layer to where, especially if a school is making an emotional decision, well, you shouldn't make emotional decisions. Okay, you should sleep on it, think about it, and just make sure that you're making the right decision based upon all of these various factors. And that's where the manifestation comes in. Now, can a school tell you in advance what they propose the punishment to be? Yes, absolutely. And some parents will go, oh, James, that's predetermination. No, it's not. What they want to do can precede the manifestation. Okay, it can, it's appropriate, it's no big deal. They can sit there and have the disciplinary hearing in advance and make a determination that there's guilt here, therefore we want to change placement of the child to alternative school or homebound or out of school suspension, whatever it is. They can make those decisions in advance of a manifestation. But at the same time, if they make that decision, they have to convene the manifestation meeting within 10 days of whatever that decision is. They've got to have it within that time. Now, once they do, they've got to look at the child's historical record. They need to look at that. And then for two reasons, okay, because there's two questions that you have to ask as a team, okay? And I would hope that everybody attends these meetings with a clear mind, like a jury almost. And that also means some introspection as a school system as to whether or not X, Y, and Z would not have happened had the school done their job and done their job properly. And I'll get to that. But the first question that has to be asked is if the conduct in question was caused by or had a direct and substantial relationship to the child's disability. All right, that's the first question that you have to consider. And I already talked about the tangent about misapplying that standard, and we don't want to misapply that standard. So the question is, if the conduct in question was caused by or had a direct and substantial a relationship to the child's disability, and that would be the diagnosis. And if the school doesn't necessarily have that answer, then maybe you need to err on the side of caution and conduct updated evaluations, thorough evaluations, like the IDEA demands and dictates. Okay. That would be a cause of concern for me if the school says, well, we don't really know. Well, that was your job. So if that was your job, then here we come to the second question. If the conduct in question was the direct result of the district's failure to implement the IEP, okay, implement the IEP. Well, how do you develop the IEP? You have to have thorough evaluations in order to develop an appropriate IEP. Well, that could get you. Let's say you have a good IEP, but gosh darn it, we don't have an FBA, we don't have a behavior intervention plan. But yet there's been a pattern of behavior very similar leading up to the manifestation determination. And if that's the case, then what's going to end up tripping you up as a school system is the fact that you didn't do an FBA, you don't have a behavior plan. But let's say you do have a behavior plan and the establishment of the behavior plan is really crappy, it's ambiguous, it's broad, there hasn't been any training toward it. Some of the teachers didn't even know we had a behavior plan. That would have to be taken into consideration too, because that's not the child. The child has the disability. The higher expectation is going to be on the adults, and it's going to be on the school system as to following these plans. All right? The child has a disability. These plans are in place to protect the child and protect the staff. And behavior plans are there in order to temporarily, and I'm not saying that it prevents discipline, because it doesn't prevent discipline. But behavior plans are intended to be there not for the child, but for the staff. So the staff understand and acknowledge that this child cannot follow the student code of conduct as it's written. And so therefore, there needs to be sort of an acknowledgement of flexibility to a point, an acknowledgement of flexibility that this child cannot follow the student code of conduct as written. And so therefore, the IEP team has made a determination that we need to be flexible to a degree on that, while we as the IEP team and general education staff have goals and that we are addressing the social, emotional, and behavioral issues with goals and with tangible services to teach replacement skills so that the behavior issue can fall in line with whatever the expectations are within the student code of conduct. School is not just for academics. One of the key and important educational performance areas in any child's IEP is also inclusive of social emotional development that would include behavior. But you sit there and you go, oh, but these behaviors, did you bother to do a good, thorough functional behavior assessment where you're trying to identify, honestly, the cause or the root issues of the behavior, the antecedents? What is the beginning point? What are the triggers? That's what you need to discover. The ABC data, the antecedent, the behavior, and then the consequence. You do that through thorough, good observations, a review of the record, discussion with the child, if necessary, the parent, and the staff, in order to put all these pieces together. Now, does the law say anything about who should be providing or conducting the FBAs? No, we're still working off of 2004 IDEA, so it doesn't necessarily specify it needs to be done by, let's say, a licensed behavior analyst. And most schools will just have a staff member do it. And I have a problem with teachers conducting functional behavior assessments of their own student. Now, why is that? Because the teacher may be an antecedent and not know it. And so it'd be like, well, you get what I'm saying. So it's good to have a neutral observer come in and analyze the situation, because the teacher can be the antecedent. I have seen that many, many times. Where is the behavior? where is the behavior occurring? So that would need to be done. But I can tell you honestly that if it's not a direct relationship to the child's disability, that next question, I mean, there's so many factors behind that IEP. Did they follow the IEP? Now, that doesn't mean the written IEP, because if you left things out as a school district, like you don't have a good behavior plan, you don't have one at all, then that's not part of the IEP. It should have been part of the IEP, and if it would have been part of the IEP, could that behavior have been averted? Was your staff properly trained in the implementation of the existing IEP or the existing behavior plan? And if some of the teachers didn't even know we had one, or if they were not trained in a tangible manner, and I'm talking about, let's say, competency, if they understood it and that they followed it consistently, which is a huge problem because a lot of schools don't train to that level. But then they want to turn around and blame the child when the child has a mistake. And then they sit there and say, I want the kid out of here for 45 days. Well, what is that going to do, guys? It's just geography. Moving them to an alternative setting is just geography. That's all you're doing, is getting them out of your hair. Quite frankly, and this is not by any means excusing the horrible, horrible, heinous things that this kid's going to pay for the rest of his life. But what happened at Parkland with Nicholas Cruz, who had an IEP and was constantly cycled in and out of alternative placements, was never really tangibly addressed these behaviors, the mental health counseling. I mean, guys, I've read a lot of what was leaked or made accessible online after Parkland. And that school system absolutely dropped the ball. And every time he would go back to his home school, which was Parkland, it wouldn't be 10 seconds before it was either a student or a teacher that railroaded him out. Now, whether that was legit, whether it wasn't, this kid was constantly cycled in and out of, the school district's different, alternative placements. And these alternative placements were not designed to help. They weren't designed to cure. They were just designed to get these kids out of, the normal schools. And, you sit there and you say, well, can you create monsters? Yeah, you can. The kid was already broken. But you don't need to sit there and take something broken and smash it even more. Not when these laws are here to be that remedy. That's the entire reason the federal government and the state governments fund this stuff, is so that we can catch the broken kids. And we can catch the kids with disabilities. There's a separation between all of those guys. I'm not sitting there saying that every kid with a disability is broken. I am not saying that. There's a lot of adults out there, and when I say broken, what I'm saying is that they've had traumatic experiences growing up, for whatever reason. That would fit into the category of, let's say, emotional disability. So don't misinterpret what I'm saying. But what I'm saying is I have so many people that rush this manifestation thing, when in reality it should be that introspection before we take that. Because look, the school already got what they wanted with the disciplinary hearing. This is what we're going to do. Okay, you're going to pay for it. That second step, that manifestation, is to have calmer heads, participate in the meeting, and look and say, could we have done better? Did we do what we were supposed to do? Did we miss something along the way? And if the answer is yes, we missed something. We didn't do this, or we didn't apply it, like we were supposed to. Then guys, you can't do the punishment. You can't do the alternative placement. And like I said, we got to sort of start changing how we're viewing punishment. Okay, because positive behavior reinforcement tends to be a lot more effective, hell of a lot more effective than what we do with regards to, our blanket idea of, let's say, deprivation, consequences. And guys, I understand. I think consequences are important in some respects, but in other respects, people learn differently. And there's some people that they only learn that way. But there's also some people that they don't learn that way. They learn through example, or they learn through positive behavior reinforcers and not the negative. And I just think that the school culture is one to where, and especially now that we've inserted police officers into schools as SROs, the mindset is that I'm going to scare you straight. I'm going to beat you. I'm going to threaten you. I'm going to charge you. And that's, look around, guys. How effective has that been? How effective has that been? It hasn't been. So we can either continue to do what everybody else has done for years, decades, a generation, 2 generations, 5 generations, or we can sit there and say, we need to take a different path. We need to explore expanded options. And we need to start addressing this in the way that the law has defined it. And that starts with individuals within administration, within the teaching realm, parents as well, working together to let calmer heads, sit in these meetings and take that personal reflection on whether the institution of public education followed the rules, did what they were supposed to, instead of blindly saying, well, if we acknowledge or we admit that we didn't do anything, then that kid's going to get away with it. Get away with what? And that's what I'm saying. You're just a complete return to the old way of analyzing these things. But I have far too many people that they'll say, well, I think ADHD's made up, or I think that autism, that's just made up. The parents are just trying to protect the kid. Don't let your ignorance of a child's disability supersede the reality of other experts that have determined that these things are legitimate. Okay? Your ignorance on the different disabilities. That's why I implore all administrators and educators to better themselves in the understanding of how different disabilities can manifest itself. Be better. And stop being judgmental. And come into these meetings with a neutral mindset. One final thing. There's many schools that will sit there and run just fly under the radar of that 10-day, where the school can sit there and suspend you out of school suspension without any explanation, no manifestation. They just don't have to tell you anything. There's nothing you can do to stop it. They have up to 10 days in a school year. In an entire school year, they have up to 10 days where they can out of school suspend your child for a violation of student code of conduct, to where they can just do it. You can sit there and say, well, my child's behavior plan, and you can't do that. They can, and there's nothing you can do about it. They have 10 days, and they can do that. Okay? It's once they hit that 11th day, guys. That's when you have to have the manifestation meeting. Or let's say your child's been suspended 3 times, but then did something that now the principal's like, that's it. I'm sending your kid away. And because of what they're proposing to do, would then go over that 10 days, that 10 cumulative days, and then they have to have a manifestation. But it's 10 days. Now, there's some schools, they're quite savvy on the fact that they have 10 days, and they don't want to use up their 10 days. So what do? They use things like in-school suspension or after school, those punishments, or even, let's say, silent lunch or not having playground time, those kind of things. All those things would be considered punishments. All right? Now, there's something within the law, a cautionary tale from the federal government, where they say, yes, you can do those, but if you're doing it frequently, and frequently, I don't know, 3-4 times would start getting a pattern, especially if it's for the same types of behavior. So if the child is engaging in the same types of behavior and receiving this sort of under the table punishment of in-school suspension or or other punishments, after school, whatever, and it's for the same behaviors, then that's considered walking into that realm of what's known as a pattern of disciplinary removals. And if you do a pattern, if it reaches that level of a pattern of disciplinary removal, then guys, that's considered a change in placement. And then at that point, you should have had a manifestation. And then you should have had that analysis of what's going on, because they're doing this for the same types of behaviors. And it's happening over and over again. And I'm sorry, but the child's not in their learning environment. And you go, well, what about after school? Well, the child's not going home. They're with you. So yes, all of these things come into play, that they're not in their learning environment, and therefore the designed IEP has been disrupted. And if it's for the same behavior, then your behavior plan isn't working, number one, which means that you need to go back to the drawing board and do another functional behavior assessment, or you didn't do one in the first place and the kid doesn't have a behavior plan, but yet you're not out of school suspending, you're in school suspension, and you're denying access to reinforcers, or denying access to typical peers, and having downtime, other things. Don't think that you're fooling anybody if you're a principal watching this, all right? We all can see it. It's the only difference is the people that are getting away with it are because most parents don't know. They don't understand that a pattern of disciplinary removals is indicative of a change in placement once it gets to a certain point. And at that point, boom, here comes a due process case. Boom, here you are under scrutiny as a principal for the decisions that you're making. Be smarter than that. Make sure you're covering your bases. And how do you cover your bases? Follow the rules. If you follow the rules, then everybody's okay. Don't you want kids to get better? Do a functional behavior analysis. Design a good behavior plan. Put good goals into the IEP. Have outside people with an expertise in behavior come in to support and train your staff. Invest in your people. And you'll see that behavior will go down. The child will get better. You won't have these problems. So that's it, my take on manifestation determinations and everything in between.